Wills and trusts, as you know, are two of the main vehicles that drive estate planning, and today I'll be talking primarily about wills. The advantages of a will are that it can limit upfront costs and time commitments when preparing an estate plan, and they're also a good solution for people who don't have a large estate. However, one of the drawbacks of a will is that it has to go through probate, which is a court supervised and therefore public process that many people prefer to avoid, and as a result, like a trust instead, or some combination of a will and a trust. In Maryland, there's two types of probate. There's administrative probate, which is managed by the Register of Wills, and there's judicial probate, which is anything that falls outside of the administrative bucket, primarily because the will is being contested or there's some other issue with it. Now, because a will goes into effect when its creator, also referred to as a testator, passes away, one of the most important provisions in a will is going to be appointing a personal representative. That person is going to be responsible for identifying the probate assets, making necessary payments, and distributing the assets. And because of those responsibilities, it's important to pick a personal representative that you trust and who can also manage those responsibilities. Now, with the will, there's going to be fees as well on the back end, which is why I mentioned one of the advantages are saving upfront costs. On the back end, there's going to be probate fees, which are based on the value of the probate estate. There's going to be compensation for the personal representative, and there may very likely also be attorney's fees. Now, there's advantages and disadvantages to a will, and it's just a matter of taking everything into account and deciding what works best. Next time, I'll be talking about a specific type of will that's used in conjunction with a trust.